Hey there, welcome to our AP Legal Zone podcast, brought to you by AP Lawyers. We are your top fix for all weekly law updates, including family, immigration, wills, and estates law. Just a friendly reminder, we are not your lawyers, and everything contained in this podcast is for entertainment purposes only and not to be construed as legal advice. Be sure to subscribe to our podcast so you can stay connected with any updates and get notified about our new episodes.
Hello, I'm Angela Princewill.
And I'm Sherine Abdi.
And on this podcast, we want to talk to you about case conferences. So if you've been served with an application, chances are you're either going for a first appearance and a case conference, or you're just going straight to a case conference, depending on what your issues are. We have a previous podcast on first appearances, so if that's where you're heading, you could listen to that. But we're going to focus on this podcast just on case conferences. So it's often nerve-wracking and overwhelming in the days leading up to a case conference. And so it's important to have essential knowledge of what to expect when you go there, things like where to meet your lawyer, for example, if you're represented by counsel. And so that's what we want to talk to you about today. So at our firm, we usually would let the client know ahead of time where we're going to be meeting at the courthouse, if it's in front, if it's at a coffee store nearby, if it's right outside the courtroom. And it seems like something so minor, but if you're looking for your client on the day off, then you start off the day, just being so disoriented. They're calling the office. You're wondering where, it really can start the day off on a wrong tone.
Absolutely, especially if it's your first time in a courthouse. It would be overwhelming.
Exactly. So it's important to know what you mean. But if you're going by yourself, then that's easier. You can ask for, directions, right? In front, there's usually the security there. There's usually someone to help, whichever courthouse that is, and you would find your way to your courtroom. There's usually, if you're ready, and I'm talking about, in person. I recognize we're recording this in the day and age of Zoom case conferences, but my understanding for most courthouses, the direction is to kind of get things back in person. So I know I'm sounding like it's in person. If you're fortunate enough to be on Zoom, then none of this matters. So let's jump into what is a case conference.
Absolutely. So a case conference is probably, for both Angela and I agree, it's the most important step in your family law process. And because of the case conference being so important, it's the first time that you're going to be before a judge in hearing your matter, in getting an idea of the substantive issues, or if your matter is through a motion to change, you'll be before a dispute resolution officer, and that would be taking place for your case conference. Now, because the case conference is the first step, no motion can be heard before a case conference and on the substantive issues unless in the situation of urgency or hardship.
And that's a very high threshold.
That's a very high threshold, and I'm not going to go into what constitutes as, what is an emergent issue and things like that. But honestly, a case conference is held to allow the litigants and their lawyers to hear the judge's views on the case at an early stage before a lot of money and resources are spent on more expensive steps. And honestly, an early airing of the issues promotes an early resolution of the disputes.
Yeah. I find that sometimes some people just want to be heard, and at least before, and even when their positions aren't strong, sometimes maybe a case conference can help them hear that. So on that note, I think we should just jump right into sort of what are the goals of a case conference, because this is where it gets confused a lot. The number of times that non-lawyers think that, at the case conference, they think it's their trial. They think they're going in front of judge. They want to bring their witnesses. They're ready. They think the judge is going to make a decision. Not so much. But before I jump into kind of what you're going to get, let's talk about really what the family law rules have set out as the goals of a case conference. So the first is exploring the chances of settling the case. So at the case conference, you get to understand how far apart you are, because one person files an application, the other files an answer. And sometimes when you're just looking at things on paper, it may seem like you're so opposed. And the reason why that's done sometimes is somebody wants to set, maybe the person filing the answer wants to set the record straight on paper. they might not really care so much. And I mean, it's not our style at this firm, but we often see people file applications with just the entire kitchen sink and even some more thrown in there. And so on the answer, you're addressing those issues just because, again, sometimes clients feel like they want to set the record straight. This is a public record. They want, the issue, they want to put their position out there. But when it comes to the substantive issues, maybe you're really not that far apart. And so when you come to that case conference, it's an opportunity for you to be able to explain your case to the judge, and the judge would be able to also explain to you, the lawyers have already done that if you're represented, but if you're not, then you can hear it from a judge. And sometimes just hearing it from the judge, that's not, and it's not from your lawyer, kind of give things a different perspective. So most times the judge would elaborate on the law. As I said, they would help clarify, previously held views. And the whole goal is to try to bring you guys closer to settling. So the first goal is to try to explore the chance of settling your case.
Absolutely. So another goal is identifying the issues and disputes. So sometimes after, thorough discussion with a judge, the parties realize that maybe they're not as, like the issues they thought weren't resolvable end up actually being, a little clearer, a little narrowed down, a little more focused. And it's also possible that, once it's taken for granted that it's not being in dispute, that they may turn out to be very contentious.
Right.
So at a case conference, like at that time, you'll also engage in like very frank discussions about the cost, the benefits, and settling the matter, proceeding with the issue. And you get real life ability to, from the judge to hear the strengths and weaknesses of each party's position. Mm-hmm. And it honestly, like at the case management stage, it is without prejudice. They're not forming part of the court record. So you are able to really explore and identify the different issues and get an input on that from the judge.
Yeah.
Or dispute resolution officer.
Yeah, wherever it is, right? So exploring ways to resolve those issues, as Sherine said, identifying the issues that are in dispute, and now exploring ways to resolve these issues that are in dispute. And it's very helpful to have a third party, in this case, the judge, give you realistic and achievable solutions, and see if there's a way they can kind of help resolve those difficult issues that they've now identified.
Absolutely. And another goal is to ensure like the relevant financial disclosure is being made. Now, oftentimes, like at that stage, it can take several months before, serving your application or motion to change. And there would be some element of disclosure, or maybe not, but this is really where if you, meet all the disclosure requests, everything is being made, either prior to this date or during this date, and honestly, as you go through your process. Yes. And honestly, as needed. But, one of the most crucial functions of a case conference is that a judge can order an order for disclosure, and, and they're able to kind of go ahead and make those orders and move the parties closer to resolving the issues.
Exactly. Because if there's financial disclosure issues outstanding, right, settlement might be impossible. Exactly. Like how someone might say something along the lines of, well, my pension isn't really worth so much. I've offered her, let's settle at this amount. Like it's really not, I don't have that much in my pension. I just got into this job. And that may be true. That may all be true. But how can the judge help you settle if they don't really see what your pension's worth? Like what's a lot really? A lot for one person could be $1 million, while for another it might be $10,000. So I know that's something that can be irritating for clients, and they're like, but she knows I don't have that much. I don't think it's worth that much. Why do I have to go spend more and go through the time and expense for this? But unfortunately, with family law, it's disclosure. What can we say? It is the way it is. And if you're the person that's needing that disclosure, you would probably feel differently. So another goal is identifying, if there's going to be expert evidence needed, and, there's strict timelines around getting expert witnesses. It's important to recognize when you need an expert even, right? Sometimes people can propose or can suggest wanting an expert for something, but maybe an expert is irrelevant, right? So the fact that someone's an expert doesn't mean they have to, if it's, a court could say, well, we recognize that you want someone, of this stature to come speak to an issue, but in your particular case, it might be relevant. It might not. So there's rules around the relevant admissibility timelines and all of that of expert witnesses, and it might be it's a goal that could be achieved at the case conference in terms of identifying issues that would need expert evidence.
Absolutely. Another goal is noting admissions that may simplify the case. So judges are good listeners. They can often get the parties and their lawyers to talk openly about the true underlying motivations, not just stating their legal positions, and help identify the common interests that tend to generate settlement.
Yeah.
So, like, again, getting down to the nitty gritty, the actual issues, not things that are inflating or creating unnecessary conflict. And really trying to get you guys closer to your legal position, not just your emotional one.
Yeah. Yep. So, and I mean, there's 3 more goals, and I'm just going to read those through because I think I can talk about them sort of as one. And it's setting the date for the next step in the case, if possible, having the parties agree to a specific timetable, and then organizing the settlement conference and, if appropriate, holding one. That doesn't happen as often. Usually with the case conference, the judges really do get to talk it out. But it's just setting the date for the next step in the case. In a lot of courts, that's if there's no settlement at the case conference, you will get a date for when to come back for either another case conference or a settlement conference. And then if there's things that need to be done, right, the judges could help streamline that. So give you a timetable. Within 30 days, you need to provide this disclosure, or we need to get whatever
evidence.
exchange, if it's appraisals that need to be done, whatever that is, and they would put it in the order so that it's clear what everybody needs to do so that the next attendance in court can be an efficient one. So now now that you know the goal, so the goal is not to have a trial. The goal is not, you would state your position, you would state your interest. The judge would try to help narrow and find common ground. But if none of that happens, people often leave case conferences where there's no settlement feeling like, well, but the judge knew that he or she was lying. Why didn't they just order this? Why do I have to come back? So let's talk about the orders that can be made at a case conference.
Yes, so, not surprisingly, there are not a lot of orders, or there's no real substantive orders that can be made. And it's very rare that substantive orders do get made at a case conference.
Very rare.
So, the judge, if it's appropriate to do so, can make several orders. One being an order for disclosure, questioning. So if either party needs to question the other party on a specific issue, they'll arrange that. Filing of summaries of arguments for a motion, setting timelines for the case, giving directions for the next steps. Another order is requiring the parties or one of them to attend a mandatory information program, which ultimately you should have done prior to a case conference. And that's honestly just the mandatory information program that the court offers. And I think they're doing them via teleconference these days, but I'm not going to get too much into that. And then they also can talk about like intake meetings for any mediation service that may be available either through the court or between the parties privately. And really honestly make an order on consent. So you guys can settle at a case conference so long as you both agree to the order that's being made, and that order is going to be on consent. So if you guys agree to a substantive issue being resolved, you can enter into an order and the judge will endorse it at that case conference. And really the judge can make any order on consent.
I like that bit, because when you're a lot of times it's nice that if you agree on something, at least let's get that order so that we can move to something else. And I know there's an art to this, and again, that's why you make sure that you're represented by good counsel. So there are some issues that if there's settlement, then we just want to get that order so that if we have 5 issues, we know we've settled 2, and we're going to spend all our time and resources dealing with the 3 other outstanding issues. But there might be times where we agree on 2 and we're like, no, we don't want that order entered because in terms of priorities or leverage or whatever the reason may be, we need those 2 issues. We need all the issues resolved. We don't want to enter into an order on this 2 because it might make the other 3 issues difficult to settle. So there is there's strategic
there's an
thinking
art
that
and a
goes,
science
yeah,
to
that
it.
goes into it. So we don't want to suggest that just because you're in agreement on a particular issue means you must enter into an order for it. You guys you could just know mentally that, okay, this is not really an issue for dispute, but we'll just park that. But there's times where it's crucial to enter into an order at the case conference. A lot of judges would give you time to go talk, to go write something, or just even endorse it and say the parties have settled the issue of XYZ, then you know it's done. But be very careful there, because if you've settled that on a final basis and you shouldn't have, you may want to talk to, at least consult with a lawyer.
And you can settle, your issues on a temporary or final basis. So it really is up to the parties, and hopefully you guys are represented by counsel if you're entering to a final order.
Yes.
So it doesn't prejudice your position or deal with an issue you didn't intend to deal with.
We often have, we have clients that are working with us on a limited scope, and we agree to be available to them on their court dates, so that when they're entering into these orders, or where there's something on consent, they can give us a call and we can advise them. But again, it's usually not the first consultation, though, because we usually kind of have an idea of their case and maybe have worked with them to some extent, and now they're attending court, and we can, tell them very quickly, like, yes, please sign that consent right away. It serves you. Or we can say, no, just leave it to a comprehensive settlement on another day. So that's, it's interesting, and it's a good thing when you can get those consent orders on at a case conference. Or sometimes too, people have actually agreed to things maybe just days leading up to the case conference, and they were like, okay, we'll just get the order issued at the conference since we're going there anyway, and it's on consent, it's done. It saves us sometimes the trouble of having to prepare 14B motions to get that issued. And
absolutely.
Yeah. And so in addition, if notice has been served, a court may make a final or temporary order at the case conference. Sherine already said this is rare, so I'm not going to talk too much about that. It's the judges really like to stay away from making orders that are not on consent at the case conference. Yeah. Okay. Do you want to talk about any of there's some other orders that could be made at a case conference, if it's relating to beneficiary designations, things like that. Again, often that's things that if you have counsel, that would already be resolved. But if it's not, then the judge can maybe make those orders. They could these are if there's notice, if notice has been served. So these are not sort of your regular things that you should accept. They could, okay, yes, that's a good one. The Office of the Children's Lawyer, if it's agreed upon, that's another thing. They cannot, at the case conference, a judge would not. It's very rare, and I know Sherine disagrees with me on this, but I know it's very rare for a judge to make an order at a case conference for OCL involvement if it's not on consent. Because
but it happens, right?
It can happen. Like they can make an order preserving your assets. They can make an order for property not to be, for someone, for an accounting of funds. So there's orders, but those are very rare.
Yeah.
The usual thing to happen is if you don't agree at a case conference, you really should be bringing a motion. That's what it's supposed to be. If we both don't agree on OCL involvement, then that's an issue that should go in front of go for a motion. I have had motions on OCL involvement or not. So I think, if my client's the one opposing OCL, I don't think I'll be very thrilled if a judge made that order. And the same goes for preserving assets as well. Can they do it? Yeah, I guess at the end of the day, so long, these exceptional orders can be made. They're allowed to make it, but it's just not the norm. If you want your assets to be preserved and the other party is opposing it, the proper order of events is for you to bring a motion. So usually
after a case conference.
After the case conference. So what would usually happen is the case conference judge would put it in their endorsement that, they might even help you canvass motion dates, which is another great thing. And if it's an urgent issue, what the judge might be able to get urgent motion dates that would not be available to the parties just calling into the court.
Leave to bring an urgent motion.
Yeah, so they grant leave. They could help you canvass dates. The dates would be set right there at the case conference. They would help you organize timelines for the exchange of documents. And the best thing that happened during COVID is then they would give you leave to exceed the page limits for your motion. So that's
that kind of
great.
leads into my next last kind of snippet. So with a case conference, like it's not going to be a big surprise what your position is because prior to, or what the other party's position is, because prior to, each party would have filed and served case conference briefs along with an updated financial statement. So, and seeking both of the orders that they're asking for and each party's position on the issues and what issues need to be resolved. These briefs have timelines that need to be, I'm not sure if you want to go over the timelines.
Nope, I'm
Because
not. I'm going to
honestly,
stay
they may
away with it
change.
because it keeps changing.
Honestly, it may change. So by that point, so there are briefs that are required beforehand. And you'll also get an idea, of course, what their positions are. So it's not going to be a surprise. Briefs are required, as well as a confirmation of notice a few days prior to, just confirming your attendance for this appearance. There are courts that take it very seriously that if you don't file that appearance, that they'll just vacate the date.
Yes, so that means you're waiting. You might be
important.
waiting months to get in front of a judge again, right? So yeah, but my most important takeaway for case conferences is I always tell clients, listen more.
Yeah.
The number of times people get upset and they think, well, you could have said this and you could have said that. It's not. I'm not there to argue with the judge. My most important thing I personally do at a case conference is hear a judge's take on my case. I would only go back to the judge and try to push if I feel like they don't understand the facts. If I can hear that the judge has a clear understanding of my facts, I want to listen to the holes they're poking in my case. And I know it's a very difficult thing for clients to hear, but if I know the weaknesses in my case from a judge, I can go back and I can rearrange my argument. And that's such a hard thing for people to hear, but she didn't know this. If I've said the most important facts, if I'm not adding to it, trust me, there's a reason. I know what the judge is doing, and I want people to adopt that more. You need to remember that the case conference judge, first, they're not making any order that you don't agree to. And what does it matter if you convince this judge? Because even if you convince this judge and the other side doesn't agree with the judge, there's not going to be an order made. It's not a motion, it's not a trial, and usually in those settings, the judges do not speak. They just let you make submissions, they walk away, and they go make their decisions, and hate it or love it, the decision's made. So you want to be at conferences, and that's something that I really love about conferences is I get to hear from the judge. So if there's a weakness in my case, I don't want to I have limited time to get this judge's opinion. I want to listen to what they're saying to me, and I want to be able to take that and go apply to my case. Maybe it might help us reach a settlement, or maybe it would help me come back with stronger arguments. And often when a third party is looking at your case, you will get perspective that both lawyers didn't have, because we're both, sometimes, especially at our firm, we started out negotiating, for example. We may have even mediated the issue. And now we're both, both sides are so locked on their positions that going in, if you're just talking and you're not listening to the judge, you lose the benefit of hearing what a third party actually thinks. And even though that might not be the judge on your case, they come with like perspective you can use.
Insight, and that's very valuable.
But on the flip side, Sherine, too, is if the judge is saying something that you don't agree with, don't get too tripped up by it.
Exactly.
Again, on the flip side, they don't know all of your case. There's page limits to conference briefs. So if we know that we have evidence that might be contrary to what the judge is saying, or the judge, despite our best efforts, the judge is not understanding your position, that's fine too. We know that this is not the judge that's going to make the final decision on the matter. So we just let it rest and we move on. And there's times when we also completely disagree on a decision that a judge might be making, because again, we disagree, right? As I tell clients, there's different levels of appeals courts for a reason. Sometimes judges make decisions that respectfully we don't agree with. So follow the guidance of your lawyers. And if you're the person attending, just be calm. You don't have to accept the judge's recommendations, but just listen, and with an open mind, if there's any weaknesses to your case, take the lessons there, or just walk away and understand that you don't have to necessarily, you don't have to accept the judge's recommendations if you feel strongly about your position. And maybe next time, come back having framed your position in a better way that might be more persuasive to even that same case management judge.
Yeah. I mean, I honestly can't even agree more, like, with everything you said. So
okay. I mean, there was some music playing in the background somewhere earlier, so if you did hear that, just take that as some free entertainment. But really, like the case conference, it's a great opportunity for, to just sum things up. It's a great opportunity for you to get your case in front of a judge or dispute resolution officer and get their insights into it. It's a great opportunity to get a settlement if possible and to get those consent orders if there is one. And if there is no consent or no settlement, if at least you could get an outline on your case and timelines on how to do things.
Maybe of the issues, and at the end of the day, like that's what the case conference is for.
And if you feel like, you didn't achieve anything, well, just take heart. Just realize that you had to do this case conference anyway. So as wasted as an appearance as you may feel, there's very rarely times where it's completely wasted. There's always something that you get. Just judicial insight alone is priceless. But let's say you didn't like what you heard and you felt it was a complete waste of time. Never mind, you have to do the case conference anyway. You would not be able to bring a motion without that case conference. Absolutely. You would not be able to move to the next step of getting your matter closer to a trial without the case conference. So regardless, you got to go to your case conference, and we hope it's, a productive one for you, and we hope that it helps narrow or settle your issues.
Absolutely.
All right, guys, that's it for now, and we will be talking to you again at our next podcast. Bye.
Bye.
Thanks for listening and joining us in the AP Legal Zone. We hope you enjoyed this episode. You can find more episodes by searching AP Legal Zone on anywhere you watch podcasts. Be sure to subscribe to our podcast today so you can stay connected with any updates and get notified about any new episodes.